This should be information that underlines what we need to do to move this country forward. Well, hello, everybody. It's June 4, 2026, and I'm delighted to welcome everyone. My name is David Leis, and I'm your proud host of Leaders on the Frontier, the live edition every Thursday. And we're delighted that we could meet today to talk about yet more important issues related to property rights. We're going to break it down. I've got an extraordinary guest, of course, and that is Professor Bruce Pardy from Queen's University in Law. And he's also the executive director of Rights Probe. So Bruce joins us regularly, and it's complex. It's kind of confusing because we heard about a significant decision that was made in New Brunswick, and we'll dive into that. And then it was appealed to the Supreme Court of Canada by a number of First Nations who didn't like the decision that seemed to assert the importance of property rights. So the Supreme Court took leave of that decision. They basically said thanks, but no thanks. So what does that mean as people started to, pop the perennial champagne corks and say, well, this means that they're standing by property rights. Is that actually true? Well, it doesn't. And so we're going to dive into this with Professor Pardy's help and talk a bigger picture here in terms of what's really going on here on this file. Property rights are fundamental to this country, and so let's pay attention here. So let's dive into the next set of the program here as we talk about comments. I learned quite a lot about your program and appreciate very much your guest choice, and that's thank you from Zenny Hudson. Thank you. And then we had comments like, thanks for choosing this topic. It's not getting enough attention. 40 years ago, we seemed to do this better. Something changed over a generation, and that's from Everyday's Tuesday. And I believe that was about a program that was just released, an interview, a long form, with two extraordinary gentlemen, leaders of the Manitoba Wildlife Federation and the BC Wildlife Federation. And that is the fight over access to Canada's Crown land. Perhaps that's related to the very topic we're talking about today. So be sure to look at that. Really informative show. Thank you. And that's from Minnie. So keep those comments coming. We get them by the thousands. They mean a lot to us. And I've always said, we have an incredible audience, and your participation means a lot. Hello from Robert Kerr from Mississauga. Another beautiful day. Isn't it wonderful to start seeing the days of summer and better weather? And I hope you are all doing well as you approach the summer season. So we've got a couple headlines right off the top here. One is Tesla is suing the Manitoba government because they were excluded over an EV or electric vehicle rebate. So what do you think about that? Was that fair to be excluded? And what were the reasons for the exclusion? There's also been a lot of votes and talk about criminalizing those people that dare question about residential schools and get into what they believe are the facts and fair discussion. In the Senate, there was a committee that voted 7-1 to criminalize Indian residential school denialism. We're not quite sure how they define that. And then later, there was another vote saying, they want to kill that Denialism Act, and yet there's still efforts to try to continue to criminalize denialism. So why is that important? That's a question I leave it to you. Are facts important? Is debate and free speech still important in this society, even though it may offend you? Well, certainly at Frontier, we think free speech is very important. The feds suspend the 15% Netflix fee. So those of you who watch Netflix probably can breathe a little bit easier, but the whole point was that Heritage Minister Mark Miller yesterday, in an abrupt reversal, suspended the CRTC order tripling fees on Netflix and other video streaming services. And apparently the speculation was this may have to do with the upcoming renewal or trade talks with the United States. We also have another topic, and that was interesting, and this is out of Blacklock's Reporter, is that the CBC was flooded with angry emails after a former TV host um, told MPs at a committee that he was instructed to keep conservatives off the air. It was kind of hard to believe as one of these moments where you said, you've got to be kidding. So access to information records show, quote, we don't hit the mark in every story, one manager acknowledged in discussing that testimony. So perhaps the CBC will learn from that. Who knows? And we also have other comments that the Prime Minister was at a synagogue this week in Toronto, announcing an effort to try to combat the massive increase in anti-Semitism in this country. And they're working to set up a kind of a council and advisory initiative about this. And so stay tuned on that one as the stats speak for themselves with this massive increase, tragically related to anti-Semitism. In other news, we know that Canada's business productivity falls for a second straight quarter, and that's according to Stats Canada. That's foundational to our standard of living. And then in other news, we have the debate about our recession. Well, we know that we are in a recession, but others have inserted the word technical. I know goes back a number of years ago, but the point is that our economy continues to stagnate. And I believe we'll get into the topic at hand now, where we talk about the New Brunswick court ruling. What was that about, and the impact potentially on other land claims, including in BC and right across the country. And the question really is strategically, are property rights still uncertain, even though the Supreme Court took leave of that New Brunswick decision? And what happens next? And what are the solutions as we go forward here? It's interesting. We've got a lot of comments already from some of those headlines. One is from Shelley, who says, defund the CBC and the mainstream media now. So the question, I guess, is why? I mean, why do we have the CBC? So the CBC can be accused of denialism for their false reporting. Oh my gosh, what a turn of phrase and an ironic twist. Also, the CBC joke film has to have consequences for humiliating a retired RCMP officer, and I think Shelley's referring to those efforts by the CBC to set up different voices and to embarrass them or make fun of them. So it's an interesting story, isn't it? Okay, so let's turn to let's just dive right into the topic here. I want to welcome Professor Bruce Pardy to the program again. Great to see you, Bruce, my friend.
Hello, David. Great to be with you.
It's great to see you. You have been one of these clarion voices in this country regarding a variety of legal issues and important files, including this one. And Bruce, I guess I want to start off with some really basic questions. One is, why do property rights matter to Canadians? Is this really foundational, or is that overly dramatic?
Oh, it's not overly dramatic at all. Property rights are the foundation of a free country. Mm-hmm. If you don't have property rights that you can count on, then you don't have very much. I mean, it's a reflection of the degree of liberty that you have. It's also the thing that we buy and sell in markets. It's the foundation of an economic way of life. And so if you do things to undermine that foundation, then the rest of your system is in peril. And that is what's starting to happen. People are starting to realize that which they thought was secure and certain turns out not to be so much. And that's whether or not they're talking about their own house, into which much of their net worth is lodged, or with respect to the businesses that operate. One of the things about Canada is that a great amount of the land is crown land owned by the government. And so the security of private property is, of course, very important, but also is access to public land. An awful lot of companies make their living off of access to public land, forestry and mining and the like. And so if the government is making up rules as it goes about private property and about access to public land, then everything gets put into doubt.
Yeah, it's hard to believe we're having this discussion, Professor Pardy, because I look at it and I think I don't think I'd ever see the day when property rights would ever be under question. Like, you've got people now impacted by these decisions. as a case in point? Because some people have kind of dismissed these issues, and we've obviously had this discussion with yourself and so many other constitutional law experts, and among others, about the significance of these decisions that are emerging over a number of years. And it's almost like we are kind of at a historic moment in the country, in the sense that, will we get a handle on this? And will we get these issues under control so that there's full confidence and trust in a property rights system, because it is so foundational? Would you agree that we are at that kind of historic moment now, where this has kind of come to the fore now finally, and we have to deal with it?
Yes. Well, two things are happening at once, right? One of them is the clash between a growing regime of Aboriginal rights, including Aboriginal title.
Mm-hmm.
And as we'll talk about shortly, I'm sure there are court decisions and there are government actions that are championing Aboriginal title over private property interests. So that's the first thing. The second thing is that as time goes on, governments are becoming more and more managerial, as in they are creating more rules and more taxes and more requirements and more limitations on what people can do with their private property. And in Canada, the government has always constitutionally been able to do that. They've always been able to take your property. They've always been able to regulate your property. They've always been able to tax your property. But it is reaching a crescendo. For some reason, they just didn't go too far in the past. In the present, it seems to be, the gates are open. And it seems to be perceived, but the governments perceive that their job is to regulate the use of private property in the public interest.
Wow.
Yeah.
No, I think that's a very good point. So property rights isn't just simply about others trying to claim superior title to your property, but it's also the government itself, through a lot of administrative law, the work of the state, to basically say, well, you own it, but we still are going to keep making claims on how it's used, in a way that just undermines the idea that you even own it in the first place. Is that what you're getting at?
That's correct. I mean, one of my favorite examples, and there's so many examples of the ways in which your home is no longer your castle. That used to be the idea. Your property was your property. It was your safe place where you could keep the world out, including the state. Now that's not so much. One of my favorite examples is empty house taxes in big cities like Vancouver and Toronto. So you buy your own property. You pay the mortgage on the property. You pay property taxes on the property. It is yours. And you decide not to be there for a while. Municipalities have decided, well, that's not okay with them. And they're going to tax you for your decision not to be present on your property. I mean, it's an extraordinary idea, but this is the place that we've arrived at. Well,
I know this sounds really super simplistic. It sounds like, you work hard, you develop your cookie jar, and somebody's trying to go in the back and basically eat all those cookies. It ain't fair, Bruce. And I know it is complicated in some respects, but the principles are actually not complicated.
That is correct. That is true. It should be very simple and straightforward. But the way government proceeds now, it's all very complex and mixed up.
Yeah. Well, I know you too are a student of history, but these rights around property go back a long, long time. And I look at this and I think, golly, there's been all kinds of conflicts, challenges, indeed civil war, when it comes to these things. Like, if somebody starts thinking that they're going to wade into your life and start taking away the things that you have worked hard to build, this is very concerning territory, is it not, Bruce? Like, things are on the line here.
Yes, and I think more people are beginning to wake up to the potential threats that are out there. I mean, these court decisions, Cowichan, for example, out in BC from last August, September, I think suddenly made people realize that the property rights that they thought were secure, the house they lived in and had paid off, that they thought was theirs beyond question, actually is not beyond question now, perhaps. And this is the fault of our institutions. Our courts have caused this problem, especially Supreme Court of Canada, and also our governments, who have either just gone along or have actually helped to push the ball down the field.
Yeah, no, it's an incredible situation that we're in. And I would emphasize that obviously we have the vision, the shared goal that Canada is the most prosperous free nation in the world. And that goes for everybody. I don't care what race background you are, but every individual Canadian should be able to have that opportunity. And so this is one of the anchor points. So we want to dive into this topic with your kind help, Bruce, and your rational thought and reason. And of course, our audience. So we really appreciate your comments. We invite those. This is obviously an important issue that matters to every Canadian. So I want to start off with a little clip here from the courtesy of Global News here that kind of sets the stage a little bit for this complicated issue.
A landmark decision by the Supreme Court of Canada is expected to have a major implication on BC's controversial Cowichan lands case. The court is upholding a New Brunswick ruling that found Aboriginal title cannot be declared over private land. The refusal of Canada's highest court to hear the appeal establishes a precedent that First Nations can seek compensation for loss of traditional lands, but they will not be able to assert ownership. The Crown Indigenous Relations Department says the ruling will inform arguments in other cases, including Cowichan, adding that private property rights are fundamental. The BC Supreme Court's ruling in favor of the Cowichan Nation found it had established Aboriginal title to more than 5.7 square kilometers of land along the Fraser River in Richmond. That decision is being appealed by the province and the federal governments and other First Nations.
I think it's important for people to know that essentially our arguments are what the court found in New Brunswick. The arguments that the province made here about private property being protected. So we think it's very interesting that the Supreme Court of Canada decided not to hear that case, so therefore leave that law in place. I think it bodes well for our legal issues here and what we're trying to sort out and our arguments that we made before the courts here.
Okay, so that was a brief clip from May 28, courtesy of Global News, that basically says, look, the Supreme Court refused a leave application in a case in New Brunswick. And so we want to break this down because there's a lot of moving parts to it. So can you tell us, firstly, what was the New Brunswick case essentially about? And then the significance of the Supreme Court to take leave on this one.
Right. So let's just off the top observe that many of the things that we heard in that clip are not correct. So the New Brunswick case is a claim brought by several First Nations for essentially the western half of the province. And the claim includes areas that are owned by 7 private companies. And this case has proceeded in a bit of a strange way. The trial has not been heard yet. And the court is nowhere near to a final call. But what happened is that the 7 companies that owned this land made a motion to be released from the claim on the grounds that there was no cause of action against them. In other words, you can't claim against us. This has nothing to do with us. Our land should not be included. Please let us out. And the court granted the motion and released them from the claim. But in the decision said, yeah, the defendants are released, but the First Nation can still claim against the land, which was the worst of both worlds, right? So now the defendants were out and were no longer defendants and therefore couldn't defend and couldn't adduce evidence and couldn't resist the claim. But the court said, but by the way, you can still claim against the Crown for the land that the defendants own.
Wow.
So the companies appealed that to the New Brunswick Court of Appeal.
Mhm.
And the New Brunswick Court of Appeal said, well, no, hold on. The defendants have been released, and the plaintiffs, the Aboriginal groups, can in fact claim against the Crown for compensation
Mhm.
for the loss of those lands. In other words, the distinction that the Court of Appeal made was between, this is going to get into the weeds a little bit, I'm sorry, but
Mhm.
Court of Appeal distinguished between a court making a declaration of Aboriginal title over land versus making a finding of Aboriginal title. Here's the difference. If the court makes a declaration of Aboriginal title over land, that means that they potentially can ask for the land back, so to speak. If it's just a finding of Aboriginal title, then they can deal with the Crown to try and get compensation,
Mhm.
the loss of the land, but not get the land back. So the Court of Appeal said no declarations over that land. That would be inconsistent with the private holdings of those companies who are now not defendants.
Mhm.
It's a violation of procedural justice to award a remedy against a party that's not able to defend it because it's not part of the claim. So, yeah, you can seek a finding of title and negotiate with the Crown, but you cannot get the land back. Okay, so that's the New Brunswick Court of Appeal. Okay, so the First Nations were not happy with that, so they applied for leave to appeal to the Supreme Court.
Mhm.
And this is what you have to do in most cases. You have to ask for permission to the Supreme Court for them to hear your case, because they get lots of applications for leave and they only hear a very small portion of them. So what the Supreme Court did was dismiss the application for leave.
Mhm.
Okay? Now, what does that mean? What does it mean when the Supreme Court dismisses a leave to appeal, application for leave to appeal? It is not upholding the decision. It gives no reasons for that call. Like this leave decision, as is normal, did not include any explanation.
Mhm.
They didn't say, well, the New Brunswick Court of Appeal is correct, therefore we're upholding the decision. That is not what it said.
Mhm.
It is simply a refusal to hear the case. Right? And what people want to do is they want to acknowledge that refusal, the dismissal of the application for leave,
Mhm.
and read the tea leaves. Like, okay, what does this mean?
Mhm.
And sometimes it can mean something, but sometimes it can mean the opposite of what people think. So
Right.
it's very risky to try and state too much from the fact that the Supreme Court has dismissed an application for leave to appeal. Okay. So
Okay.
the last binding statement on this case in the law is the New Brunswick Court of Appeal. It is not Supreme Court of Canada. Supreme Court of Canada has said nothing about this case. Okay. So, but if you want to read tea leaves, you could go like this. You could say, well, here's a case where the New Brunswick Court of Appeal basically said Aboriginal title shouldn't prevail over private property.
Mhm.
Okay, and the Supreme Court refused leave to hear that case, so therefore Supreme Court must agree.
Mhm.
It's possible, but it's not for sure at all.
Mhm.
Here are the reasons why it's not for sure. This is a strange situation in this case, as I was describing. So you have a situation where the defendants, the owners of the land, because of the procedural steps earlier, are not defendants.
Mhm.
And neither party, neither the companies, the private owners, or the First Nations were appealing that part of the decision. The defendants didn't want to reconstitute the claim against them,
Mhm.
and the First Nations didn't want them back in the action. They wanted what the first judge said, which is, no, you can try and get that land without them in the action, right? So the Supreme Court had in front of it a situation where putting the defendants back in was not really an option, right?
Right.
So it was a very strange situation. The question was a much narrower one than the conflict between Aboriginal title and private property. The narrower question that the New Brunswick Court of Appeal was deciding is it okay for a First Nation to seek a declaration of Aboriginal title in a situation where the owners of the land are not part of the suit.
Mhm.
And so Supreme Court just didn't want to go there, didn't want to touch it. That might be because they were sympathetic, or it might be the reverse. It might be because Supreme Court down the road, maybe, and if it hasn't even thought about it yet, but it might be that they want to maybe endorse something like what the Supreme Court of BC has said in the Cowichan case.
We don't know.
We don't know, and this is and from the Supreme Court's point of view, this is probably not the ideal, straightforward kind of case to make findings about that basic relationship.
Mhm.
Now they could have done us all a favor. They could have said, all right, well, this is close enough. We're going to make some statements, even in obiter, about what the relationship is between these two competing interests. They chose not to do that. They've left us hanging. They've kicked the property can down the road.
Mhm.
They have not done us a favor, but on the other hand, they haven't actually come out, one way or the other either.
Wow, what a great walkthrough, Bruce, on really a kind of a complex case there. But the punchline is a bit like, well, maybe it's like the Oracle at Delphi. We don't know what the Supreme Court is thinking. We can't be mind readers here. So
Right.
we have
And
to be
also, let's
very
acknowledge
humble
this.
about that.
Sorry, David, go ahead.
Yeah. No, we have to be very clear-eyed and humble about the reality that the Supreme Court technically has not spoken. Just because they've been silent doesn't necessarily mean anything.
That's correct. And keep in mind that there are 9 judges on the court, and they're not going to think the same thing. And they probably didn't sit down and all together and say, right, what's your position on this kind of an issue? Should we take the case? So it's not even a monolithic opinion inside the court. There are going to be different voices there, and those voices are not going to speak until a different case comes along.
Indeed. So in this case, we basically have a situation, though, where property rights are still uncertain.
Yes.
So this, I would basically characterize this as a situation where we're really back where we've always been, and that is post not just August, what was it, technically August 6th, that the BC Supreme Court came down in terms of the decision regarding Cowichan, the land in Richmond, but the lead up to this over many years. And so, Bruce, this is a very helpful clarification. I think that other voices, including law professor Dwight Newman, have weighed into this, have also said that the decision to grant or deny leave then is not a direct indication of whether the court agrees with or doesn't agree with the decision below. So I think his comments are the same essentially as yours. So in this case, though, I want to, and it's interesting, all the comments that are coming in here, I think there's also been a number of you that have said that comments like, cracker crumbs, instead of dividing the country, why are the Indigenous not included as a natural Canadian citizen? And I guess I want to just pick up on that question then, Bruce. What is really going on here? Why? It seems like we've got a myriad of claims. It's not just, 3 or 4 of these kinds of legal matters, but it looks like hundreds. In fact, if the truth be told, we actually don't technically know the full number because many of these are also being negotiated under the cloak of darkness. So Canadians are not even like, by golly, you think that there'd be a transparent process where we're looking at these issues so Canadians can see what's going on, people can have confidence and trust, but that's not happening. So we don't even know the full range of cases, and there seems to be a lot of them. That would be the understatement of the day. So why is this happening? I thought all Canadians were equal, to pick up on, the audience's comment here. What's driving this, Bruce?
It's an idea. There's an idea that is directly opposed to the one that you just mentioned. And that idea is that in the law and in the Constitution, Aboriginal people are a different category of people. And for my money, that is a category error, right? You can't, for my money, you can't run a country that way. So let's just be clear about what kind of rights we're talking about. Every Aboriginal person, and we might even ask, well, who is that? What's the definition of the category? But let's just put that aside for a moment. Every Aboriginal person has today all the rights of a full Canadian citizen, right? The right to vote, and the right to own property, and the right to marry, and the right to have a job, and the right to make all of the regular, normal citizen rights, both in the charter and outside, that everybody has. Aboriginal people have too, right? And of course, that's the way it has to be because they're Canadian citizens. Right?
Yeah.
But they also have a special category of rights and entitlements. And why is that? Well, because of this idea that has long been embedded in both Canadian law and in Canadian culture. It is now entrenched in Section 35 of the Constitution. It says, essentially, that the Aboriginal rights, treaty rights, Aboriginal title are guaranteed constitutionally as of 1982. Well, as of 1982, there was a certain roster of rights, and that was probably a mistake itself. But what has happened since 1982 is that the Supreme Court of Canada has taken that guarantee in Section 35 and basically championed it, expanded it, reinvented it, redefined what those rights and entitlements are. And over time, because of that dynamic, we have reached a situation where all of these claims are coming out. You have the Cowichan case, you have the case in New Brunswick, and we are now getting to the question, after all these years, about whether this vision of expanded Aboriginal rights and title that the Supreme Court has over time articulated is in fact prior and senior, and those are the words that the Supreme Court of BC used, whether or not Aboriginal title is prior and senior to private property owned by other Canadians. And that is the question the Supreme Court of Canada has not yet answered, whether or not you can take property away from the fee simple interest holder and hand it over to a First Nations on the basis of a land claim. We don't know that yet.
Wow.
But the Cowichan case in BC said it implied that you could, calling it senior and prior. And that's essentially what the first level judge in New Brunswick said. And that's the thing that the New Brunswick Court of Appeal disagreed with on the circumstances of that case, right? So we have a clash. So let's go back to the basic idea. One of the problems with Aboriginal rights is that they are group rights. They are not individual rights. So if you have a band with a reserve, or if you have a group with Aboriginal title or the like, that's a group right controlled by the leaders of the group. That doesn't mean that every individual member of that group gets a fee simple property in that territory. Those individuals are subject to the leadership of the group, right? It's sort of like a little constituency, a captive constituency. And what we've done is create a whole bunch of small hierarchies, all led by a set of elites. And this is proven to be to the detriment, not just of other Canadians, but also to the rank and file normal members of the Aboriginal communities, because they don't have any power over this either.
Yeah, right.
It is serving the interests of the elites, both within Aboriginal communities and within governments and the Aboriginal industry, so-called, the policymakers and the lawyers and the consultants and so on. It's become, if I may say so, a bit of a grift, right? It is become a black hole of government largesse, lots of money, both in land claim settlements and other kinds of payments, have regularly come out of government coffers and into a black hole, and nobody knows where it goes, because there's not very much accountability. That doesn't often end up in the hands of rank and file Indigenous people. So it is a serious cultural and systemic and legal problem that no one wants to confront, because as soon as you say this is wrong, then you get accused of being, anti-Aboriginal, which is not
Right.
true at all.
Yeah, no, of course.
right.
Wow, what a summation there. You've heard that today from Professor Bruce Pardy. I think it's one of the best summations I've heard of kind of our situation here. I think you've mentioned a very important date, 1982, with the introduction of that part of the Constitution and kind of an expanded view of Aboriginal rights, but in a particular way as it's translated into group rights. And then it's like this has just become a train that all kinds of agenda have been piled onto. Is that like, I'm trying to
Sure,
break it down as an analogy here,
sure.
that has
And we
picked
should,
up speed. And it's almost
yeah.
like it's ingrained now, not just as a legal train, as it keeps expanding those rights,
Mm.
juxtaposed to Canadian rights. Like, I think if we ask just about any Canadian on the street and you ask them, well, don't we all have the same rights? We'd say, yeah, of course we do. I mean,
Yeah.
that's so top of mind within our way of thinking that of course we have equality of the law, but we
Right.
don't. What
No, we
you're
don't.
telling us is just like, wow, the world has been kind of put upside down, not just yesterday, but over a number of years here. That's the
Yes.
summary.
Yes, that's absolutely true. And to this story, we should add more recent developments like UNDRIP, the United Nations Development on the Rights of Indigenous
Right.
People. But before we go there, let's just go back to the main proposition, which is if your law creates different categories of peoples,
Mhm.
then that means by definition, not everybody has the same rights, because some of them are going to belong to one category and some are going to belong to another category. Now, sometimes people who are interested in certainty make the following kind of proposition. They say, well, let's deal with this pragmatically. What should happen is the government should go to all these groups and negotiate with them and finalize like new treaties and decide, what the rights are and so on. My response to that is, look, you are making the same mistake. As soon as you say this group of people should negotiate with this group of people, you are dealing with different peoples. My proposition is there are no different peoples, folks. Everybody is an individual. Yes, when the British and the French arrived on this continent, there were distinct peoples. There were British and French peoples, and there were members of Aboriginal groups. They were different cultures, very distinct, different technology, different histories, different language, in all those ways. They were different peoples.
Mhm.
But that was a long time ago.
Yeah. There's been a lot of mixing now, Bruce.
What
Would you
happens
say?
is like migration and invasion and mixing is the history of humanity, right? If you
Indeed.
look anywhere across the world at any portion of historical time, you'll
Mhm.
get this happening. And what happens is new people move into new territory and they mix with the people who were there,
Sure. Yeah.
right? And what you get is a distinctive third thing. So the proposition that today there are distinct peoples who in the law should be recognized with different kinds of rights
Mhm.
is itself the problem. So even in our language, when you and I are sitting here talking about Aboriginal people, okay,
Mhm.
very difficult to explain the situation without using that language. But even that is making the mistake, right? If you actually have what I think consists of a free country governed by the rule of law and equality of treatment in the law, that means you don't have categories. You have everybody who has the same set of rights. And we are a long way from that.
Wow. Talk about a wake-up call. Like, this is almost overwhelming because it's like as a country, it's like we've had some institutions kind of run on a different track, and the track has diverged from where we assume to be equal in rights to a point where now we've got a whole system that's built up, a whole system of money, power, everything that's predicated on this idea that you said, Bruce, that somehow there's group rights and they supersede other individual rights. I mean, this is just like South Africa, isn't it?
Well, yes. So I mean,
That's
one
hard
of
to
the things that has in common with South Africa is that people think of the population as consisting of different groups. In South Africa, there's black people and white people.
Yeah, it's bizarre.
And
yeah.
And as long as you have that distinction in your law, then you've got a problem, because now you have governments with the power and discretion, and especially even courts with the power and discretion to decide, all right, which group should have more and better rights than the other group. And this is not based upon individual actions. I mean, one of the basic legal propositions is that you're responsible for your own actions, right? You make a contract, you have to keep the contract. You commit a crime, you do the time for the crime. But we don't have the idea that other people are responsible for your actions. So if you make a contract with somebody, you're responsible for the contract, not your uncle, because your uncle is not part of the contract. He didn't make the contract. It's you, right? Yeah. If you commit a crime, they're not going to put your neighbor in jail because you committed the crime. Yeah, it's personal responsibility for your own actions. That is an idea that is not being followed in these ways when we say that this group has these rights and that group has those rights. This group is a group of victims, and this group is a group of perpetrators, and the members of this group or members of this. I mean, it's ridiculous. We are going back in time to decide who is alive today based upon their lineage, based upon their family tree, based upon some ideas that have not even been articulated, why it is that those people have rights and those people do not. So in all kinds of ways, it doesn't make sense. But again, people are scared to talk about this.
Why are they scared to talk about it? Like a friend of mine is Gad Sad, and I can hear him articulating well that we have a kind of a suicidal empathy. We've placed empathy, with good intentions, the desire to be caring, to be able to bend over for perceived, victims, people who have had a raw deal. And so in that empathy, that has almost superseded rational thought or debate or truth telling. And there's always a healthy debate to try to, reach truth. But when you say afraid, Bruce, what's your theory on that? Would you agree with the Gad Sad?
Oh yes, and I expect one of the things that he would say or agree with is that suicidal empathy is a way to raise yourself in your own mind. If you are the one being empathetic towards somebody that you regard as below you,
like to feel righteous,
like you feel righteous to somebody who needs your empathy in order to make it through, then you have just raised yourself up to a level above them.
Wow.
Right. And this is sort of, I mean, I hate to say it, but this is sort of consistent with the way Canadians think, right? Just think of, for example, the way Canadians speak about America. Right? The favorite Canadian thing is to be morally superior to the Americans. Why? I really have no idea. I mean, I don't know what it is that we all think that we're superior to them about, but it is one of the things that seems to allow Canadians to feel good about themselves, to think, well, whatever way they're better than us, they're not better than us morally. So suicidal empathy is a different thing, inside the country, but nevertheless, it's a way to raise yourself up without really deserving it.
Wow. Gosh, so these decisions, I mean, this is quite I think I sense this from the audience. This is a little bit mind-blowing, is that this isn't just about the law. It's about deeper things. The law, the decisions are kind of reflective of what kind of the culture is thinking as well, and our perceptions of these issues, right? I mean, you're a law professor, Bruce. I mean, you know that the law is often based on the belief of precedent and common law that should be making decisions based on individual cases. But that's kind of being put aside too, isn't it? If you emphasize more group decision making and that type of ideology, then the law is changing to something else, isn't it, Bruce?
Many people tend to give the law too much credit for being something that it's not. I mean, I like to say that the law is just a way to make political decisions that makes it look as though there's something else. all the trappings of the legal system,
Mhm.
precedent, judicial reasoning, written decisions, rules of evidence, all those things make it look as though the decisions that are being made are somehow more pure or wise or guided by principles rather than, bald politics.
Ah.
And sometimes they are. Sometimes they're based upon precedent. Sometimes they're based upon the words in the statute.
Mhm.
But often they are also political decisions. More and more, especially at Supreme Court, courts are admitting, in fact, saying it out loud, that they are making policy decisions. And when a court makes a policy decision, I don't really see the difference between that and a political decision made by some other political representative. And yet our judges are not elected, right? So the idea that the law is solid and predictable and not subject to human frailties
Mhm.
is just not borne out by the evidence.
Mhm. Okay.
And so I think we should be a little more skeptical about the results that are fed to us.
I think that's a very wise comment that reflects the reality of the law, and that's a very helpful comment, Bruce. So as we turn now to the reality of our situation, we've got a lot of cases in play, that still continue to put uncertainty regarding property rights to be very clear. We know this. Just because the Supreme Court took leave on that New Brunswick decision really doesn't mean much at all.
Right.
But what we do have is a situation that is difficult now, not only because of the way the law has evolved since 1982, as you mentioned, and it's kind of an expanding view of Aboriginal rights, but also the layering of yet another complication, and you've alluded to that, is UNDRIP,
Yes.
which was, of course, at best a kind of an aspirational document. If you read the UNDRIP, you can look it up, you can see it. It was never meant to be, Bruce, as I understand. I mean, if you read the document, it has some good rhetoric in it, but it was never meant to be a legal document that could be used and operationalized. And yet, our federal government and certain provinces like BC have actually adopted it. So what the heck is going on here, Bruce? Why would they? I mean, I have spoken with the former Attorney General of BC. You can watch the interview with my friend Michael DeYoung. And he even asked, when the BC government was introducing it, has this been red tagged or yellow tagged as legislation? In other words, has legal counsel within the government that have they reviewed it? Have they said basically, is it red tagged as in it's unacceptable or not? And clearly the government of the day didn't answer the question. They knew that this was barking up the wrong tree and it was going to create a royal mess. Am I being too simplistic about this, Bruce?
I don't think so. So the UN Declaration is a General Assembly resolution. And as you are describing, that document in and of itself is not legally binding. Well, you couldn't take it into a Canadian court and say, look, here's a UN declaration. Could you please enforce it? The court would say, no, it's not the law of Canada. But the BC legislature and Parliament have both since passed statutes that incorporate that document into BC and federal law.
Wow.
And in the case of the BC statute, that statute was passed unanimously by every member who was in the chamber at the time.
Yeah. Unbelievable.
Right? And what that statute does is require, and this is basically the words, requires the BC government to ensure that the laws of BC are consistent with the declaration. Now, what does the declaration say? It's pages and pages of rights and entitlements for Aboriginal peoples, including the idea that they are entitled, basically, to any land that their group ever used or occupied. And it's not qualified. It's just an open-ended statement.
Wow.
Right? And so, I mean, if you read it on its face, you think, well, they can't be serious. But then it becomes the law. And you still think, well, they can't be serious. But here's what's happening. In BC, the NDP government is taking that as a literal mandate. And they are making agreements, usually secretly, with various Aboriginal groups over various territories,
Mhm.
recognizing either Aboriginal title or granting management rights over the land in that territory. One of the earliest and best examples is Haida Gwaii. BC
Right.
government made an agreement with the Haida Council recognizing Aboriginal title over the whole of Haida Gwaii, even though there are private BC residents with private property on Haida Gwaii. So now those people don't know what the status of their situation is because their private property hasn't been canceled, it wasn't taken away.
Mhm.
But on the other hand, there's Aboriginal title over the whole thing.
Mhm.
And you can't, if you read the agreement, you can't tell who's in charge now. Is it the province? Is it the Haida Council? Is it the local municipality? Is it the federal government? Because the government says, the agreement says that all of these institutions have their jurisdiction over the
Wow.
territory.
So are you saying that with these agreements and UNDRIP, the adoption of it, they've introduced a whole new series of complications and basically given a de facto kind of co-management approach, another layer of government, where if you're doing something, it's not just the British Columbia government, duly elected, it's another group that's not even elected, is going
That's
to also be there in the co-driver's seat trying to drive down a big road. That's complicated enough with one government.
That is correct.
Is that
And you
it?
can see that happening now in the areas where these agreements have been made. These councils or bodies that have now new jurisdiction are making decisions about what people can do with their property or whether or not they can have docks or so
Yeah.
on. So or shutting down, provincial parks. This is unknown territory, and it is the government that is doing it. So there's these two tracks. One is government driven, especially in BC.
Yeah.
And the other one is court driven, primarily by the Supreme Court of Canada, but that's where the decisions like Cowichan come from.
Wow. So the government in some cases is driving it. So this is where, well, we've had for years, and I get this, there may be treaties or understandings around land that on the edges can be debated and questioned because there may have been mistakes made or proper claims. That's one thing. There's a well-established process to deal with those things in a
Well,
good way.
even that's becoming problematic, right? Because there are a lot of claims now in the courts challenging the meaning or the validity of these treaties. So the fact that you have a treaty is not necessarily the end of it, especially if the courts are oriented to believing that this is an outrage, a tragedy, a historical calamity that we have to remedy because they're victims and the Europeans were perpetrators, and anybody related to the Europeans is still a perpetrator, and therefore even though there's a treaty, we have to go back and revisit it.
Oh, I see.
There's a whole psychology here.
Yeah. But that's kind of the ideology, right, of the Marxists who kind of say, well,
there is
you
a
guys are all
relationship.
settlers, so you should all pay up, and kind of like along those lines that are taught in some courses in universities, right?
Sure.
That's it, right?
There no doubt is a relationship there.
Yeah.
It's not direct. The Aboriginal idea, the idea of Aboriginal people as a different category of people has been around, in Canada for a long, long time, maybe forever, right? Starting with contact and treaties, because they were at the time different peoples. This is the thing.
Yeah.
We start off at a period where there are different peoples.
Yeah.
But if you insist that the idea must continue through time, even though we're all mixed together now. So let's put it this way. Let's change the location for a minute. Okay, if you go to Great Britain and you say, all right, well, we're going to go back in history and try and figure out who owes who what. Right? You say, well, who are the aggrieved parties in the UK over the course of its history? Well, the Celtic peoples were there starting at a particular time, and then the Romans came and invaded, and then the Saxons came along, and then the
Don't
Normans,
forget the Vikings and the Normans.
Vikings, and then of course the Scots and the English have their complaints, and
Right.
all right, so if I was a Brit, and I had a mixture of And who would know? I mean, I wouldn't know probably. But let's say I had a mixture of Scottish and English heritage, but the English heritage was Saxon and Norman. And it's like, all right, so do I owe people things or do they owe me things?
Right.
Like which group now am I supposed to belong to? And what roster of rights should I get that's different from the guy who lives down the street? And the answer is no, people, you're all British. And the attempt to go back to history to figure out who you're connected to and therefore what rights you should have in the present day is ridiculous.
It's kind of a fool's errand, isn't it?
It really is. But that's the game we're playing here in this country.
Wow. Well, that's a stunning example, Bruce. I really appreciate that because, you have to kind of be clear-eyed about this and say, look, if we're one country, let's act as one country.
Yeah.
If we're equal citizens, let's act as equal citizens and respect each other, build a prosperous country, and let's go. It seems to me that this is a recipe. It's a dead end in public policy, as I say. It leads us to nowhere in a positive way that builds the future for our country. And I think it's going to break this country apart. If we don't have property rights and things aren't clear and simple, why would anyone rationally invest money in this building this country? And I think this is why it matters. It's not only a sense of justice, but I mean, we've had all kinds of major investments in this country that have been put on standstill. There's a reason why our country's in recession is because we've got all kinds of things that are uncertain. And if it's uncertain, then why would you invest in something? You just fly over Canada and say, forget it. I mean, it's a country that's, it had its era of prosperity and now it's done because they can't give a clear answer to basic questions.
Right.
Is that right?
That's very well put. Cannot provide an answer to basic questions. That's exactly right. In many ways, the governance of a country and its constitution should be simple. It should be based upon very simple principles. But in Canada, that is not so. Everything is tied up in knots.
Wow.
And there's still in this country, well, maybe more every year, we don't call it by this term anymore, but there's a political correctness that boxes us in. And our ruling class, if I can put it that way, is very dedicated to these myths, if you like. They dare not step outside. Now, there are exceptions. And those are hopeful among the political class, but for the most part, the mainstream, does not have the courage to say, you know what, folks, we've been making a mistake for a long time. We've been making a mistake about the way we think about this. Let's see what we can do to fix it. But that doesn't happen very often.
Yeah, no, very powerfully put, Bruce. It's very frustrating, very concerning. I remember doing analysis about the 1982 Constitution as a pretty young fellow and squarely coming down that it was a mistake. But I know that there was a lot of enthusiasm for it. I know there's a mixed bag. There's pros and cons. But one of the things that I appreciated was one of my professors at the time made it an eloquent point that in the UK, the tradition of the Constitution isn't so much a written point, although you could argue that common law as it's written is certainly part of the DNA of the Constitution, but it's really the understanding within the common culture of how we treat each other and how we relate to each other in a way that is relatively easy to understand is really where the Constitution lives. And my concern now, Bruce, is that our culture has been kind of infected in a way that with thinking and ideas that are not really enabling us as a country to be able to self-govern well. If you don't have those basic answers to basic questions, as we we're talking about, you're not really governable anymore. And that very much concerns me. Does it concern you as well, Bruce?
Oh, yes, absolutely. And so this is part of the danger in having those systems, which have worked very well at times in the past. The common law. The common law at times has been a tremendous tool for providing a way to resolve disputes without violence.
Indeed. Yeah,
but
indeed.
if your common law and your unwritten constitution are in the hands of your elite decision makers like courts, and those people don't think the same way anymore, if they don't think of themselves as restrained, if they don't value the same things that the country used to, then the nature of those tools means that those institutions and those people can just go and change them. There's no restriction on the way, well, only in terms of legal method is there a restriction. So let's go back to property for a minute, because there's no property rights in the Constitution, right? So that means,
can you repeat that?
there are no property rights in the Constitution. There's Aboriginal title.
Yeah,
that's guaranteed, but regular property, fee simple property is not guaranteed.
Yeah, the irony is stunning. Yeah.
Right? And that means that legislatures have always had the constitutional power to do to your property whatever they want.
Wow.
It's just that they haven't. Well, they have through history, but they haven't as much as they are now. And now they seem to be, they think they're no longer fenced in for some reason. They now think it's their job to interfere with people's use of their property.
Fascinating. Well, as we kind of get to the end of our far-reaching conversation, Bruce, I want to talk about policy solutions, because, out of this complicated situation, this conundrum, what is the vision for going forward? How do we move forward? Well, obviously, one of them would be to repeal UNDRIP. This has been, I think, articulated by many, is that we need to realize that UNDRIP was never meant to be a legal method for so-called reconciliation, but rather it was inserted there for political reasons, and it's created a mess. So let's get rid of it. Would you agree on that, Bruce?
I not enough.
Not enough.
I mean, yes. Yes, that has to be done. So you would certainly want to repeal the BC statute and the federal statute that incorporates UNDRIP into BC and federal law, for sure.
Yeah.
It would be nice to have a section of the charter that talked about property rights, but those two things are not going to solve the problem. I mean, you have to repeal Section 35 of the Constitution. Okay. We have to confront and correct this idea, which is that Aboriginal people are different people than everybody else.
Okay.
As long as the law carries inside of it a different roster of rights for that category as for that category, then you still have a problem. And no amount of negotiation or reconciliation is going to fix that. So let's just go right to the core of the idea of reconciliation. In order for reconciliation to be a viable idea, you're talking about the coming together, the reconciling of two groups. And my point is, there are not two groups. There are not two groups. There are people. There are individuals. We are all individuals. And as soon as you put them into two groups, you've already made the mistake. So in that respect, I am not in favor of the project of reconciliation, because reconciliation is making the problem worse. It is confirming the situation that we're trying to fix.
When we should be emphasizing the equality of all Canadians and working together to build this incredible country. That's the opportunity. That's the Canadian dream. And yet we seem to be flushing it away, and we're kind of paralyzed. So it's going to take enormous political leadership now to move this forward, because the courts are kind of, caught up in their lane of thinking.
Yes.
But so this is the dilemma, right? So how do we move this forward in terms of a roadmap? Obviously repealing UNDRIP is just a small part of it, but it's a fundamental idea that you are challenging, Bruce. And I think that's really quite remarkable to have this kind of conversation today, because you rarely ever hear about this in the public square.
That is absolutely true. And that is a reflection of the problem. It's a reflection of how deeply this idea is embedded in Canadian law, but also in the Canadian psyche. If you just went out onto the sidewalk and asked somebody at random, whether they thought that Aboriginal peoples were a people, they would say, well, of course, what are you talking about? Because the this is the world we live in. It's the world that we're taught that we live in from the very beginning, right?
Indeed.
But it should not be this way. It is the continuation of a historical fact that existed long ago. But all those people who were there, who were alive at the time that this happened, are dead. And those people who are alive today don't live in the same world that existed at the time. We are all mixed together now, and should be. That is the sign of a healthy country. And I mean, I don't know how healthy Canada is, but in other words, for the law to insist that the categories that existed, 200, 300 years ago is a very bad sign.
Yeah, let's be real. This is 2026. So my question then to you, Bruce, is what can citizens do? Because obviously awareness about this is extremely important. Our attitudes. I recall the quote from John Stuart Mill, who said, "The only thing necessary for the triumph of evil is that good people do nothing." Is this not the role of the citizen to be able to, share this discussion, talk about this in a good way with fellow citizens, and say we need to move forward as a country? We can't be stuck in the past. We need to move forward as equal Canadians.
Yes. Absolutely. But this problem that we've been talking about today is just one of the several albatrosses around the Canadian neck. People, I think, if they, got the wherewithal to say to each other and to their political leaders, this is not going well. We are on the wrong track in so many ways. This is one of them. We have to stop treating our people as different categories of people. But also, here's some other things. Our Constitution doesn't work very well. We are governed by an aggressive managerial state that is doing all the things with respect to our property that we mentioned before, but also interfering with all kinds of things like our speech and our commerce and our so on and so forth. So a lot of Canadians, I think, are having difficulty recognizing the country that they live in. And that's because a lot of the ideas that it was based upon have sort of gone off in the wrong direction. And it requires, I think, a sort of a fundamental rethink about what this country is about. But the prospect of getting there is very difficult.
Well, Bruce, I want to thank you very much, Professor Pardy, for having this discussion. It has been quite an eye-opener as we've talked not only about legal decisions and their significance, but how they are a symptom of something much deeper about what it means to be Canadian and what this country means for each of us. So I want to thank you so much, Bruce, for your discussion today and your leadership.
Always a pleasure, David. Thank you for having me on.
Well, and thank you everyone for joining us today. To our guest, Bruce Pardy, as well as MCA Media, our producer, Lorraine, and to each of you for joining us. We want to thank you for your comments across the board. Be sure to like and share. Look at our YouTube channel, and be sure to join us next week. And here we are on Leaders on the Frontier, and I wish you a terrific week.
Here at Frontier, we don't receive any government funding. We are nonpartisan, and we work for you. Find out more and support this important work by visiting fcpp.org today.